Welcome to Crime News with Mark Solomon. It's Friday, September 17, 2021, and today we're going to be talking about Lori Vallow and whether or not she has been faking her lack of competency this entire time. We're going to talk about some articles that we're going to do a deep dive into, and we're also going to have three important updates on other cases first. Stay tuned. But before we get to that, don't forget to click that like button. It really helps the channel out. I really appreciate it. If you want to subscribe, do that too, with a little bell next to it to be notified of future videos. Let's get to it. First thing we're going to talk a little bit about is yesterday's bond hearing in the Alec Murdaugh case. And the judge yesterday afternoon set his personal recognizance bond to $20,000. Personal recognizance bond, meaning all he has to do is sign his name and he gets out. If he doesn't appear or if he gets into any more trouble while out, then he has to cough up the $20,000 in most cases. That's it. That's what happened yesterday. So he is out of custody now. The next thing of note is the Barry Morphew case. As we all know, was a preliminary hearing, took 4 days, about 2 weeks ago, was set for the judge to give his opinion as to whether or not probable cause existed. That's set for today at 1:30 p.m. in Chaffee County Division 2. I would bet money that the judge will find probable cause, but we'll see. If I can, I'll do an update later today on that. Next thing, 3 months later and about 1,200 tips later, the Tennessee Bureau of Investigation says no update on Summer Wells. She is still missing. If you know, here is the tip line if you have anything to contribute. So, let's get to our next and most important topic of today. This is Lori Vallow Daybell. She has been in custody now in civil commitment for about 100 days, give or take a day. And that commitment is for restoration. Just to refresh your memory, Lori Vallow was committed on June 9 when she was found not competent, and when that happens, she gets remanded into the custody of the state for restoration. That's where the psychiatrists, the psychologists, the therapists, they work with her to try to educate her on the issues of whether or not she understands the process, whether she understands what she's being charged with, the roles of the people in the court, and whether or not she can assist in her own defense. It's a really low bar. I've had clients who've been not competent, and it's usually fairly apparent. It's usually they are out there. And so when you have this issue where so many people, I have had so many comments from so many readers saying that she was competent, she wasn't competent. Other people were saying that she's been faking her sanity, and that all of the things that she's been doing and saying just bespeaks to her lack of being sane. Other people say that whether or not she's competent or not competent on the beaches of Hawaii, she passed a competency exam and pray the court allows it. Of course, she didn't. The court saw that the defense's competency evaluation and the state's showed that she was not competent to stand trial. And the next question, with all of these folks weighing in on one side or another, I really wanted to look at this issue in depth. And how do you do that other than to just break it down and talk about each part of it? So let's do that. I have found two really good articles that talk about the issues of faking competency or lack of competency. One of them is a 1995 article that I found, Detection and Malingering, Incompetency to Stand Trial Evaluations. The other one is a 2018 article, Review of Approaches to Detecting Malingering in Forensic Contexts and Promising Cognitive Load-Inducing Lie Detection Techniques. That's a mouthful of a title. We're not going into depth on the science and the psychology of these, but I think it's important to look at what they're saying. And I'm going to put the links to all of these articles in the description below so you can read them. And when it's over, I'd love to hear your thoughts and comments about them. But first, let's dive into the facts surrounding the cases that she's charged with, the circumstances, the deaths, the missing folks, and just the slew of stuff. Let's switch over to the handy-dandy crime news death timeline for the Vallow case. Notice the disappearances, the deaths, the alleged self-defenses, the kids being missing for almost 2 years now. And Tammy Daybell's death a month later. Alec Cox died in December of 2019. She wasn't taken into custody for a little bit after that. The real question is, could she have had enough time to set up a lack of competency situation which was believable? I prep people for trial. I prep witnesses for trial. And I'm telling you, people cannot fake something for hours and hours and hours on end. They do or say something to give themselves away. And in this case, after 100 days in a 24-hour, 7-day a week, this is one of these situations where Lori Vallow has been observed for 100 some days. I do not believe a human being can fake something that convincing for that long. Let's get to the articles and we'll go over. The first article I want to talk about is the detection of malingering being a crucial component of forensic evaluations. They talk about the ways they're going to perform the evaluations, and I've highlighted things along the way. So again, if you want to read more, please download this article and read it. The focus of this study was to address feigned incompetency by comparing incompetent, competent, fake incompetent, and control respondents on quantifiable competency instruments. And the participants were specifically instructed to fake incompetency rather than being given more vague instructions like to fake bad or fake crazy. They were told just to fake incompetency. They weren't told really what it was, but we'll get to what they thought later on. So this article talks about the methods, the participants, the instruments that they use, the procedure, which is really interesting. You should read that. And they talk about how the demographics work in the results. We're going to skip down to the discussion here. For most of the criteria evaluated, the most difficult discrimination was between the fakers, simulators, and suspected malingerers, and the incompetent respondents. In other words, these are the people who were trying to tell the difference between the actual incompetent people and the people faking being incompetent. This difficulty may be due to the incompetent respondents having more psychopathy and therefore endorsing more test items on the keyed direction. And interestingly enough, to me, this was the most interesting part of this article, the strategies of deception. The simulators seem to adopt the more is better approach to faking, tending to respond to every item. In other words, I don't even know I'm on planet Earth, let alone that I'm in a courtroom or that I have an attorney. For example, simulators provided many absurd responses like, what's the function of the judge? The answer would be to laugh. And things like all courtroom participants were said to have the same function. Many I don't know responses. Interestingly enough, I've seen that, when you're explaining something to somebody and they're faking that they don't understand it, they say, yeah, I don't understand anything you just said. And you say, well, tell me what you don't understand. And they say all of it. And I say, well, did you understand the part where I told you you're a defendant? And they're like, nope. Can you explain that? And so sometimes that just raises those red flags that the person may not be being honest. This corroborates what I've kind of thought all the years that I've had to do that type of thing. It seemed less that the specific and more open-ended the question, the more difficult to fake, and therefore the more absurd the response. Here in blue. In contrast, genuine incompetence often had partially correct answers that were not accurate enough to indicate competency. They did not, however, provide absurd responses. So in other words, if I were to extrapolate that, what I would say is that an incompetent person or somebody who truly does not know what's going on, when they're asked the role of the judge, they may say, to sit in a black robe at the front of the room. Whereas the person faking incompetency would say to laugh, or aren't they the one who gets up and dances during the middle of when I'm talking, or something ridiculous. So interesting, this also tends to indicate the simulators were informed that a finding of incompetency is directly related to courtroom knowledge, but virtually all of them extended this meaning to incorporate symptoms of psychopathology. Slightly more than 1/4 of the respondents provided a correct conceptualization of incompetency. The remaining participants provided answers such as being crazy or unstable or out of touch with reality or unable to make decisions. These strategies suggest the possibility that these inmates had prior contact with mentally ill people, providing them with a reasonable notion of its manifestation, as in the ones who evaded detection, right? So that's interesting to know. The people who evaded detection may have had prior contact with mentally ill people. Okay, so there's one way somebody could prepare. For example, participants who endorsed items that were unusual or responded deceptively to all the questions were more easily detected. However, simulators were quite unsophisticated in their faking strategies, tending to fake incompetency through the use of layperson's conceptualization of mental illness. Okay. We recommend, and this is the end of this study, we recommend that more research incorporating suspected malingerers be conducted. Now, remember that, because we're going to come back to that in a minute. The next article I wanted to talk about is this review of approaches for detecting malingering from just 3 years ago. And remember, both of these articles were ones that I found on the internet. They're freely available. Links are in the description. And the abstract here, and the point is, these are things that Lori Vallow could have read. It's possible. Malingering, the feigning of psychological or physical ailment for gain, poses high cost on society, especially in the criminal justice system. In this article, we review some of the costs of malingering in forensic contexts. The most common methods of malingering detection are reviewed. The shortcomings of each are considered. And as a type of deception, we argue that such cognitive approaches and understanding be adapted to the detection of malingering to supplement existing methods. The article starts off talking about the DSM-5, defining malingering as the intentional production of false or grossly exaggerated physical or psychological symptoms motivated by external motives or incentives. This article goes into the negative effects of the misclassification burden on the criminal justice system, the measuring of malingering detection accuracy. It goes into the types of ways that people fake, the ways that they can be unearthed, and at the same time, it assigns a percentage to that, strategy methods for detecting the malingering cognitive impairment. It talks about the assessments for psychiatric malingering, and this structures interview reported systems, or SIRS, seems to be the most highly regarded test for detecting such malingering. It is an interview-based measure that consists of 172 items. As an interview-based test, it's interesting to note that a lot of this is going to be subjective to the interviewer as to interpretation. So the primary scales are rare, symptom combinations, improbable and absurd symptoms, blatant symptoms, subtle symptoms, selectivity of symptoms, severity of symptoms, and reported versus observed symptoms. And it talks about how the interview process can take significantly longer than the administration time of 30 to 40 minutes suggested by Rogers. There are other types of tests like structured inventory, which is a pencil and paper screening detection for malingering. There's the MMPI-2, which is a 567 item self-report measure where somebody fills in 560 some bubbles and are asked many questions, often the same question worded differently, to see if somebody is actually reading or paying attention to the questions. And it says here 55% of individuals with genuine mental disorders have been identified as malingerers. Interesting. So it's got a 50-50 shot, roughly. There are other self-report tests like the Miller forensic test called the MFAST. This article also goes into the assessments of cognitive malingering, like the TOM test. Also is a 50% chance of choosing correctly, even if they're guessing. Here's the Ray 15-item test, or the FIT test, which it says does not meet the Daubert standard. In legal parlance, just means that this FIT test will not be accepted in a court generally unless something about it changes, because it means that it's not generally accepted in the science field. Not a good test to use if it's not admissible. The word memory test. And then there's a long section on lie detection, where it talks about, despite advances in malingering detection technology, current methods are far from adequate. with high rates of false positive, false negatives, and a susceptibility to coaching. Perhaps the detection of malingering can be facilitated by incorporating developments from the field of lie detection, given that malingering is high-stakes deception. Current methods of lie detection are reviewed with an emphasis on innovative cognitive-based approaches. Think about that for a minute. A susceptibility to coaching. Human lie detectors, and it talks about how unreliable human lie detectors are. We review some emerging technologies. It talks about arousal-based techniques like control question technique, like the polygraph, and how this is fine, but again, not admissible in court because it's not generally accepted as good science. There's the concealed information test or guilty knowledge test, where they try to get you to admit something in the test, or they hit you with some sort of detail that you shouldn't know, or something that you should know, and it makes you edgy, and that makes you fidget, and that makes you look guilty. Like here, part of that test has to do with cues of response time, event-related potentials, pupil dilation, and this is the CIT. It's limited in the deception that it can uncover due to the false denials and those possessing concealed knowledge. There's cognitive load-inducing approaches, which, again, let's skip to the end here. Once refined and validated, such techniques may accurately expose malingering in forensic settings, perhaps used in conjunction with other methods. There's asking surprise questions, soliciting surprise drawings, having to maintain eye contact. I thought this one was pretty good. This is where the interviewer has to maintain eye contact because somebody who is being deceptive has their anxiety go up if they have to look at somebody in the eyes while lying. Okay, I think this is also missing a point, and that point is that if somebody doesn't care, in other words, they don't want to go to prison, so they'd rather go to a mental hospital, and at the same time, they didn't care that they killed people, and now here they are facing either life imprisonment or even death, or life in a mental institution. They would much rather go to the mental institution. That cuts both ways. On one hand, they could say, if they don't care about killing, how could they care about lying? And on the other hand, if they really don't want to go to prison, then maybe that ups the stakes that they want to be convincing, but staring somebody in the eye that entire time might make them have more anxiety. And how do you measure that, they say? One likely countermeasure, as knowledge of this load-inducing technique spreads, would be to practice lying while maintaining eye contact with another, which might reduce liar-truth-teller differences. Even so, combined with other techniques, it may be useful in revealing malingering in forensic contexts. And this is often used in conjunction with the polygraph, which measures galvanic skin response, blood pressure, and breathing. Customary methods for malingering detection were viewed to rely on atypical levels or combinations of symptoms, unusual performance on cognitive tasks, or behavioral anomalies. And this is the part that we kind of end with. Sadly, their rates of false positives and false negatives tend to be high. Not good. In conclusion, the more that malingering is understood cognitively, the more that they can understand the methods of lie deception detection. In other words, they're not that great. So when you observe somebody 24 hours a day, 7 days a week for 100 days, is it possible that she could be faking? Yes. Yes, it is, especially if she's familiar with mental health disorders, if she has practiced, if she has little conscience and doesn't mind lying and is good at it, has practiced and has not broken from her act and has no cracks in her armor to show her true light from behind, then I think it is possible she could be faking her incompetency. But, let me be clear. While I think it is possible that Lori Vallow could be faking her incompetency, I think it's highly, highly, highly unlikely. This all comes down to personal interpretation of the test, the application of the test, and the interpretation of the results. Now, she was able to fool two evaluators, one from her own camp, one from the state, and now she's probably got a battery of folks looking at her. And the real question is she a good actor or not? She is not getting out of custody if after 170 more days she comes back into the courtroom and is still found incompetent. Another issue to touch on, back just yesterday, I found this article where the question is being asked, should she be forced to take medication? The prosecutors want to know. And here we've got a motion that was filed about a week ago in Madison County, where Prosecutor Rob Wood and Fremont County Prosecutor Lindsay Blake asked the judge to allow them to interview medical staff and other Idaho Department of Health and Welfare staff. The state is performing its due diligence, and they're trying to find out if it is worthy to ask the court to allow the state to force medications to make Lori Vallow competent for the trial. And that's a great ethical question as to whether or not the state should ever be allowed to do that. The judge is going to hear the issue, assuming that the judge allows the state to interview those staff. A closed court hearing on Wednesday was related to Daybell's mental health commitment. Chad Daybell's next court date is now September 20, related to motions filed by the defense, including one pertaining to DNA. And those are not available for public view. So that's what we've got for you today. If you have any thoughts, feelings, or comments about this, remember, you can always download the links. And if you want to put anything in the comments, I would love to read them. All of your comments are so special. The fact that you took the time to write them, I appreciate that. If you have any suggestions for future videos, always looking for those. And until our next video, thank you so much for watching.